before the violation of number 3. But the central ground so on this personal ground, you must release this matter. And the lordship fix this matter before any.
How I can fix the matter before any other bench? I have understood what you have said, that she will not hear the matter. But for assignment, I don't know whether it can be done by this board. You'll have to mention before the Honorable Chief Justice. Yes. What is the provisions? You cannot assign the matter. Assignment or the determination of what has been done here. Not any problem. As I agree to find out. So I noted very well answers. Ask somebody.
Number one.
But page 9, my lord, is the written complaint that has been written in Bengali, my lord.
You have given a translated copy.
Yes,
You have a translated copy. Don't give like that.
But if the lordship, my lord, a short password, my lord, I will make it out.
Is the case diary here?
Yes,
Is there a narration of the
Yes.
FIR?
My lord,
yes, forwarding report at page
my
8.
lord, the gist of the complaint.
I don't want to see. It's POXO.
No, my lord, so
No.
376 and only 511.
375, 511.
Attempt to commit rape. But the gist of the complaint itself reveals that
Matter is released. Decision shall be heard by free. Automatically, I have nothing to do. Where is that, sorry, that madam, she was mentioning a matter this morning that has been released. A mentioning was made that some matter has been released by a bench. Why not? I asked you, you said tomorrow. First me.
Only by PS, which we are allowed.
No, there-
Last place open.
Your friend was, you were sitting here, she was making a mention that it has been released by her ladyship. Somebody was there.
What?
Ask her to, ask her to see the determination made by the Honorable Chief Justice. It says if released by this bench, it will go to that bench. If released by this bench, it will go to that. It is automatic. So nothing is required to be done. Just show her. Ask her to come and verify. Yes. Then she can just approach the registrar, it can be done. Yes.
Number two.
Arrested.
This matter should be after a long time, just filed on, now has come to not press. This is a case for rejection, my lord. My lord, just go through the affair of the case, it's written in English. Yeah, holding the CD also.
Page
I was
number.
also present.
Page number.
My lord, I'll hand over the CD, my lord. This is the original FIR. On the first page, and the fake royalty. What we are-
FIR is of a long time back.
This person should not be honored. Again, they will come and file an application. They should
How can
reject
they?
it.
How can they? Once they have withdrawn, how can they come again?
So they have the opportunity to move, we are not.
At least in these 4 or 5 days, I have seen second anticipatory bail at already about 4. That appears to be a practice here. What can be done? Whether withdrawn or rejected, where
It will be rejected and there may direction to
there is
surrender.
a prayer made by the learned counsel for the petitioner. Quantity
97 bottles of my lord.
But not from my position. Kindly tell you the page name, the FIR. The allegation is that on 7th of December.
It's all about my lord, cross-border smuggling of my lord, the narcotic substance. It was intercepted by the border security force who was on the duty, my lord. They were my lord, about to smuggle my lord with a bike, a motorcycle that has been seized, my lord. The whereabouts of the motorcycle has also been revealed that this particular petitioner happens to be my lord, the owner of that.
Yes.
my lord,
Does he have any antecedents?
Also,
Does he have any criminal antecedents?
but that I have to take.
Please find out.
Also.
My lord,
The Learned State Council is directed to verify. Let it come day after, day after.
also.
Find out properly, ask him to ascertain.
The charges under section 326, 307 and 34 of the Indian Code. Now,
Where is the translated copy?
my lord, translated for my lord, I have stated in paragraph 4 below. The list of the FIR, my lord, well, that
You don't bother to go through the last order.
translated.
I have directed for giving a copy, is translated copy. Why should I rely on a gist or any summary that you have made? The court has to see the FIR and its contents. Bring it tomorrow, not today. When there is an order, you are saying I have stated in the paragraph 4. It was not there on the last day.
Number 5.
I have put a stake in this matter. It's the wildlife matter.
And for that, that complaint, my lord, is case 6, my lord.
Dada. Wildlife Protection Act. Wildlife Protection. Wildlife Protection Act. Wildlife Protection.
My lord,
Section 9.
Section 9 is no person can hurt
No person
Why
can
not?
hurt any wildlife.
any wild. Sure.
Not hard, hunt.
It is hunting, it's not hurt.
So, and not as simple as that.
And hunting is defined in section 2,
Yes.
16.
16 and 235.
This is amount to hunting. The allegation is that the elephant has been electrocuted.
Yes, sir.
Perhaps they had barricaded by way of an.
Yes, sir. That was illegally done. The fencing was illegally done and the connection was drawn from his house. The connection was in the name of his deceased father, my lord. Two brothers were involved.
No,
Subsequently,
paragraph 6.
wait, sir. Let me, you first make
No.
your submissions and I will start. Lord Chief, now there is a subsequent seizure followed by the statement, recovery of this electric arm, this wire and.
Yes,
article.
bamboo and wire has
Yes.
been, that is
Seized.
there in the FIR.
Yes, madam. No, there is a subsequent recovery, madam. This is a subsequent.
Correct.
Yes. The electricity bill they have received, that substantiates that the connection was in here.
No, it was in Meghalal Mandal's name.
Meghlal Mandal
Their
is the
father.
father of these
Correct.
accused persons. Meghlal Mandal died, madam. After that, both of them have been enjoying it.
Hunting
Now-
has been defined in 216. Just have a look what
Madam.
hunting says. Says killing. It's not a case of killing. A death has occurred, but it's not a case of killing.
Also, full-grown major.
Killing or
madam.
poison
My lord,
any wildlife.
both of another brother was arrested, man. Another accused person was arrested. He had to be released because he was not surrendering. He was not. He was absconding. Ultimately, trial could not commence. He has actually obstructed.
One of the brothers has been arrested.
Yes.
Yes, madam. He has been released on bail after considerable custody because that he was not found. Trial could not be commenced,
You
madam.
cannot get a better.
Kindly see paragraph 6.
Yeah.
Milord, I am
How
a day
does-
labor. I work in Kerala. Milord. It is done by
Work in?
Kerala, and it is done by Milord, my brother Milord, Babu Mondol.
Have you given anything to show
No,
that you
Milord,
are
I have
working?
made paragraph 6. Milord, kindly see paragraph. I
Have you
have
given anything to show that you are working in Kerala? Any piece
day
of
labor. Milord,
day labor, you must be getting some payment. You must be having some something to show that you are in Kerala.
then can you make it Milord one?
Give something so that there can be something to at least.
And my brother is cultivated.
The learned counsel for the petitioner submits that he will substantiate the statement made in. Okay.
My lord, I am appearing on behalf of the petitioner. This matter is being led by Mr. Shurajit Boshu, who is appearing online from Kolkata.
I am for the state.
Mr. Abhimanyu Das is appearing on the petitioner also. He will hand over the translated copy of the FIR as directed by.
My lord, with your permission, I am handing over the translated copy of the first information report.
Allegations are under section 126, subsection 2, which corresponds to section 339 of the Indian Penal Code, section 150, subsection 2, which corresponds to section 323 of the Indian Penal Code, section 117(4), which corresponds to section 325 of the Indian Penal Code, section 105, which corresponds to section 304 of the Indian Penal Code, and section 3, subsection 5, which corresponds to section 34 of the Indian Penal Code. What has happened in this matter? The son of the de facto complainant and daughter of the accused number 1 they had a romantic relationship. They got married. A case was registered by the accused persons, and thereafter dispute arose. And due to such dispute, the incident took on 30th January 2025. We are the principal accused is one Anjana Roy and Dhaneshwar Roy. We are the distant relatives of the accused persons. Lordship may kindly sees the role attributed to the petitioners, and Lordship, I have instructions that perhaps charge sheet has already been submitted. So therefore, there is no further requirement of custodial interrogation.
10 accused persons.
10 accused persons actually,
And 9 accused are named and 20 unnamed. 29%.
actually 32, so far the 164 statement, there was a love affair between
That the alleged daughter-in-law has been examined.
yes, exam.
Where is her statement?
Actually, I'm giving the memo of evidence because here it is written in Bengali. The gist is written in English.
No. Give a translated. No gist. I want
The
to
Lord
give-
kindly fix it tomorrow.
Yes, not today. As paid, not so. As paid by Land State Council. As paid by Land State Council for supplying translated copy of the statement of the daughter-in-law. Matter is adjourned for the day.
1st May. Kindly fix.
All right, first.
Wait for this.
Very good.
Number 7.
Petitioner, I am handing over the supplementary affidavit in here on that and it's the translated copy of the expired matter. Page number 10, ma'am.
Supplementary is more voluminous than your main application.
Page number 10, my lord. It's
I'm on the stage of
expired. I have already served a copy.
Copy has been given to you?
Yes, sir. Open the.
Copy has been given to you?
Yes.
My lord, kindly turn to page number 34 of my supplementary. My lord, and the previous occasion also has said that this petition number 5 has already been arrested. So I am not pressing his bail at application, it's a bail application.
Fifth accused is a female.
No, madam. Shahid Ali, Mohammed Shahid. Female is petition number 2, madam. Tamina B. My lord, petition number 1.
In your translation, you have upset the entire list of accused persons.
No. Translated according to my lord FIR, as he has lost, not according to my petition.
No, because in the allegation about the fifth accused, there is allegation of destroying and damaging the van. So fifth accused is who? Who is the fifth accused as per FIR? Then
Wife of Muhammad Sabi.
yes, she is a female.
Female.
So she has been arrested.
Okay. Mohammed Said.
Fourth.
So fourth accused has been arrested.
Number 4.
Yes.
Arrested on 19th April
20?
2024.
Yes.
My lord, and one thing to say, petition number 1 and 2 in my, according to my bail application, anticipatory bail application, are senior citizen, my lord.
1 and 2.
Yes, my lord. One is aged about 75 years and Chamina BP is 70 years. They have misleaded by writing the wrong age, my lord.
It's difficult, very difficult to correlate what you are submitting. You have given a translated copy in which this is not tallying.
My lord, translated copy age is given according to the FIR age.
Your petitioner number 1 is Muhammad Sapiul. He is accused number.
It's number.
Look at the main copy of the FIR, not translated copy. It is there.
One.
1 and Chamina is 5 and
Aged 70
and
one is aged about 75.
and
And
Samuel,
40 years.
what he is accused number?
I have 2. Hamid
And Sahin
and Shahin 4.
and Syed Ali.
Shahin, my lord, Shahin is accused number 3 and Shahid is 4. Shahid is 2.
So according to you, Chamina has been arrested.
No, my lord.
Syed has been arrested.
Mohammed Said.
Syed is not accused number 5.
But the,
Syed is accused number 4.
4.
Yes.
As per memo of evidence, it was accused number 4.
Yes. No, as per FIR accused number 4. Yes.
Yes. A memo of evidence also.
And he has sustained injury. Is there any
Yes,
injury
I
report?
have already,
Once kindly come to page number 34 of
Just
the
a minute,
supplementary, my lord.
but the injury report at page 33, but I have already shared.
Unless there is a long pending civil dispute
Yes,
regarding a land, my lord, and for that, my lord, they have also assaulted us and fighting took place between the parties, my lord. I have annexed all the, my lord, civil case shoot papers, my lord, and all, we have also filed 144 subclause to CRPC in page number 34 by Safiul, my lord, and Atiyar is de facto complainant is one of the
What
parties.
kind of weapon it says?
subtracting weapon, look.
Does it? No. What is this?
No, I
Please see what it says. You have a copy. What does it say here?
have kindly come to page number 34.
Just wait, I'll see everything.
As per the seizure list, one iron rod, bamboo stick,
So perhaps it says stick.
stick.
Does it say stick?
They attempt to hit the injured person on her head, but subsequently somehow he managed. And his right shoulder and chest has been reduced.
Stick.
Stick. As per the serial list mirror at page 16. I don't know that stick was this from the spot.
Oh, this is the bruise.
Yes. Somehow he managed, but
Yes. And who is the accused number 4 has been arrested?
arrested. Mohammed Said has been arrested.
Alright. At the very outset, the learned counsel for the petitioner submits that the accused number 4, namely Syed Ali, has been arrested and therefore does
I'll get to know. Number 8.
What do you want? As paid by Learned Council by MS so and so, the matter is adjourned to the next circuit.
Item number 9.
I am appealing on petitioner.
I have been put.
Lordship, this is my renewal for application. Lordship, earlier-
Second anticipatory.
Lordship.
Sorry.
Earlier it was rejected on 6th of November 2024. Lordship. Lordship, the case is under section 108 and section 3 and 5 of the Bharatiya Nyaya Samhita, which is 306.
Where is the earlier rejection?
Earlier rejection is Lordship, NSA P3. Lordship, NSA P1. Lordship. 4 accused persons were there. Out of them, petitioner number 2 was rejected. That is the petitioner before your lordship. Lordship, allegation is that
This is a regular bill.
no, 438.
P3 is
P1. Subsequently, I. In this application, 4 petitioners were there. Out of them, 3 petitioners were allowed, and the petitioner's application was rejected.
in November,
Yes,
November 2024.
November 20.
and you are still rooming large.
Lordship, the allegation is that.
Sorry. Yes, sit down.
Lordship, where is submit?
No
Lordship, where is
second.
submit? Kindly.
Such person, after 6 months, you are coming a second anticipatory bail application.
Lordship, there are changing circumstances.
Maybe, where were you for so long? Where were you for so long? For 6 months, you are evading arrest after rejection of the anticipatory bail application. Then what are you doing since November? Tell us, tell the court. Such a person deserves a second consideration.
So kindly let me make my submission, Lordship. Lordship, the allegation is that the principal accused, there is the Borun Rai, he used to provoke the victim girl.
I am not interested. The court has recorded findings. The court has found that allegations are made against you specifically by name. I am not going to review the earlier order. Apart from that, what do you have to say? Tell me.
Charge sheet has been submitted and
That
has already been enlarged on bail. Lordship.
You will also be, who's saying you will not be enlarged on? Yes,
That is
third
the involvement of the petitioner. Lordship.
third learned counsel for the petitioner
What is the
and the learned counsel for the state.
Your allegation is under section 14A and 14C of the Foreigners Act. Petitioner is the Indian national lordship. Allegation is that he harbored Bangladeshi national and gave shelter.
Now, this is the FIR, he is an Indian tout.
Yeah, FIR is here. It is there at page P2.
And they are what they do, my lord, they by taking huge amount of money,
Lordship,
They
other
give
similar
shelter to
case
the
were
Bangladeshi.
solved. In those cases, the petitioner was relied on anticipatory bail by this honorable.
wow, what a criminal antecedent, my lord.
Same case, same section.
And even now, if he is granted anticipatory, again, he will come with the same offence. The next time my learned lawyer can file another 2 bail orders.
That will help you.
I don't know. But that will not help our.
Which is the earliest?
nation.
Out of these three cases, which is the earliest? One is Uchli Bari PS case 150 of 22.
Definitely, my lord, 450 is
Thereafter-
applicable to the, not to the foreigners, it's applicable to the person who has habited, who has done the harboring. And the punishment, it's a special act, the punishment in this case, abatement is same to the offense of the main offencer, which the principal accused has been
What is
arrested.
the case number
156,
of
2023.
22? Such an old case.
Once this will be taken into custody, let there be a custodial interrogation, my lord.
No,
then-
what has been, there's no steps taken by the prosecution since 22.
They are abscond, my lord. They are
That
absconding,
is
but-
why, that is why I am asking you. That is why I am asking you. 84, 85, nothing.
Because other accused persons are there. They have been arrested.
No, whether you have
They are
any
arrested under the 14.
84, 85, you have any
No,
inspection?
no.
Not done. There is no steps taken.
No,
The Translated copy?
Yes.
And that is the 164 statement of the victim logic, where she has had a statement that regarding the allegations logic, that she voluntarily had gone to. She had voluntarily gone with the accused logic.
Stood the allegation were other loss contract, or my name to the. Because over the outside the parents.
She is a major.
At that time, Lordship, it is the case of 2017, Lordship.
2000?
From 1617, Lordship. Way back. So after 9 years.
Hmm?
21, petition of 21, and victim 70, and that 70 class.
I can't read the allegations and this is not very clear. Give a copy of the FIR. As paid by learned counsel for the petitioner, comma, for submitting translated copy of FIR. Matter is adjourned for the day.
Number 12, which bring all this see and look at everything in the.
As paid.
Item number 13,
Not paid. Same order as 11. Give your appearance.
Agenda 14.
None appears. Adjourned for the day. Earlier,
The state is represented by which case diagram?
So I will put that reference.
14 years.
none appears. Matter is adjourned to the next session.
Agenda 15, state matter.
15, I'm appearing online with your lordship's leave. Malad, if I may just recapitulate, Malad, on yesterday the matter was, I'm obliged. I'm sorry.
Yes, on the issue of maintainability.
Obliged.
So yesterday, this point which was raised here. And what has fallen from the mouth of my lord is that having concurrent jurisdiction, can an application or modification, or whatever it is, be filed under section 439(1)(b) of the Code of Criminal Procedure from an order of session judge. To my little understanding, I understood that this is the cross point of argument.
You are praying for?
I am praying for lordship relaxation of the condition of bail. Kindly lordship sees page 22 of my.
Yes, what do you have to say on the maintainability? How it is maintainable?
Lordship,
Yes.
may I, though it is known to my lord, but I am facing a fact, lordship. Lordship, though under 438 or 439, the.
You have examined the issue.
Yes, sir. I have examined the issue, will find my respectful submission, it has to be under 482.
Has to be.
Because the concurrent power is only restricted to 439(1)(a).
Correct.
So far as 2 is concerned, it is magistrate, and there is no judgment which says magistrate also includes for the purpose of this the session.
That's
So
fine,
at least
but
I could not find a judgment.
if he is aggrieved by the order, he has to assail the order.
Correct.
If there was a rejection, then you could have come here.
Well, the question is now whether your lordship can treat this as an application under 482 or can convert it as an application under 482.
That can be done. Why not convert it? Why unnecessarily do
After.
something like this?
Yes, because this is a council brief, so it has been filed on this section. So to justify the filing, Lordship, I'll take only 5 minutes, Lordship.
No, there is no question of justifying any filing. An error has been committed, it has been committed. There is the question of justifying the.
Lordship, may I place a judgment in that?
Yes.
Reported in 2015 SCC online, Madras 258. Alice's Lordship, the first paragraph. May I read it?
About it.
Just let us know.
Yes, sir.
This question has not been dealt with.
This was also an application of 439(1)(b). And from the
Principal does hello. This question has not been dealt.
This is a criminal original petition.
Lordship.
This is not a.
Lordship, first line. Under section 439(1)(b) of CRPC. Our case is also under 439(1)(b) of the CRPC. So here the High Court has.
But the issue has not been considered.
The issue has not been considered, but similar circumstances is there.
So this is not an answer to the court's query. The court's query is whether it can be done under this provision or not. What has happened after that, nobody knows. Just because another coordinate bench of another state has done it, that does not mean it has to be done. The issue is whether it can be done or not.
This is not, I submit fairly, this is what I got after research. Now, Lordship, if apparently an injustice or illegality has been caused, then my lord can, while reading the application, invoke the special provision under 482. This is also a central provision.
There, the order has been passed by the principal district judge.
Lordship.
Yes, my lord.
Very peculiar.
My learned friend can withdraw this and file a fresh petition, my lord.
1B is very clear. And that is a concurrent jurisdiction against exercise by the district judge and the high court. Only in relation to an order passed by a magistrate. Therefore, there is no question.
Now, Lordship, kindly consider one aspect, Lordship. When a 437 application is rejected and 439 is filed before the district court, and it is rejected also, then also Lordship will come before the High Court. Though High Court and session judge having concurrent jurisdiction against that order of district judge under the special power of the High Court. So if bail application is treated, Lordship, why can't the modification? I ask a question.
You ask yourself a question, give me something. Don't ask yourself a question. You argue the matter. I asked you to come prepared on this matter.
I have filed only. I have got only.
Then don't ask yourself a question. Either you resolve.
This has been dealt.
You are here to assist the court, not to ask a question.
Lordship, if the High Court can entertain a bail application passed by the rejected by the district judge, session judge, then Lordship, the modification rejection by the session judge, the High Court, in my humble submission, Lordship, can entertain. Because the contrary to the section.
And if your lordship permits me, my lord, I will try to assist your lordship on this question, which my learned friend just now raised himself.
Yes, you may say whatever.
My lord, I'm obliged, my lord. If your lordship sees 439 1A, there is no forum mentioned. So therefore, for filing of a bail application before the High Court under 439, my lord,
This is the
it
issue
may be
which has been settled since long.
exactly. Your lordship
Which
is
has
right.
been
Your lordship is
settled since, this is nothing new.
right. Your
This
lordship is
happens
absolutely
throughout
right.
the country and it has been settled.
Right.
This concurrent jurisdiction.
Your lordship is
how it
absolutely
exercised.
right. But so
Whether
far,
Yes.
clause B is concerned, this has to be a court of magistrate.
Yes,
So here
B
my
will
learned
not
friend will.
apply. B will not apply.
I'm sorry, my lord.
B should not
No,
apply.
but right, but in this application, but it's a application under 439 1B,
That any
present
condition-
application, which is why it's not maintainable. He can
Magistrate-
withdraw and file a fresh
Well,
under
magistrate is
482.
must be defined.
Magistrate is everywhere defined, but in the act. The power of magistrate, if your lordship finally comes, my lord, finally comes to my lord. Section 6 defines the courts.
Correct. So magistrate is magistrate. You will not come within the district judge will not come within the expression magistrate. Yes, you want to amend the petition or what do you want?
Lordship.
I think, to that extent, my submission will be there is no provision for amendment. If I may just request your lordship to see once, 401,
This will be renumbered.
he has to, file a fresh,
That is a
there is no
different
corpus.
classification.
Yes, that's right.
It's a different classification also. Your lordship is absolutely right.
Then what can be done?
Leave may be granted to the project.
The
But I'm for the state government. Earlier application one report was filed for. A report has been filed by the.
when we are not proceeding, why? The issue of maintainability of the present application has been raised by submitting that the provisions of 439 within bracket 1 within bracket small b will not apply in the present case where the conditions have been imposed by the session judge and not by a magistrate. By a learned magistrate, not by a learned magistrate. By the learned session judge and not by a learned magistrate. Stop. In view of the objection, the learned counsel for the petitioner seeks liberty to withdraw the application, seeks permission to withdraw the application with liberty to file afresh under the appropriate jurisdiction. Stop. The application is accordingly disposed of. So second becomes
Bless your
purpose. There are two. Only one.
Only one. Only
One
one.
application
Bless your
also
lordship.
two orders.
Yes.
Obliged your lordship.
Grateful, Lordship.
I'm on state, brother.
Item 16 and 17. Item number 17, and for the opposite party also. The next copy not served.
16.
Item number 16 and for the petitioner.
None appears for the petitioner. List on Thursday. First. Both cases, there is no one to represent the petitioner. Only.
Number 18.
Who is for the respondent? Why have you not filed a opposition yet? You are filing.
As a matter of taken up for hearing, I was busy in court number 3, that's why.
Give a copy.
Okay, sir. Okay, sir. I have to send the copy to your chamber and you have received.
Or she will be served upon the senior advocate instead of the advocate.
No, he's saying it is served on the office. If it is there, then.
Say left, just get the office.
So it is there.
Efficiency should be used before the court.
Yes, yes. I start it at your
Anything and
chamber
everything should not be submitted.
and accept your junior.
No, it was not
Anyway.
accepted by the junior, it was accepted by the clerk, but the girl who takes care of the GST file.
Whatever it is, I don't want to enter into that. The propriety, he knows better. And you are there to guide him. But since there is substantial service.
And the way you deliver, I doubt the propriety. Doubt the propriety.
The DSG's office is receiving the application.
No, but if the,
Position.
it is not the GST.
Served by my junior. You serve.
How can you serve a copy on the clerk?
Again, serve.
You should do that.
If he wants, I will again serve.
Do it today. The opposition is being filed
Nothing.
by the learned counsel for the respondent to stop. He submits that a copy will be served during course of the day on the advocate on record. Has been served on the advocate on record in court itself today. Stop. Yes,
Can we take the day after tomorrow?
as paid list on.
Because tomorrow we have elections.
You have election.
Yes,
Yes.
process.
As paid
Yes,
list
by
on.
the nothing works.
First. You don't want to file any reply.
But I have to go through it. One leave may be granted to me, I will file.
That is why.
That is a
Great,
very-
but will be served during, has been served in court today के बाद, the learned DSG appears, he submits that. After going through the same, the liberty may be granted to them to file a reply if necessary, full stop. Matter is accordingly adjourned to the next circuit. In the meantime, if you want to file, you file.
Number 19.
Item number 19, I'm appearing on behalf of Commissioner, Your Lordship.
Yes.
This is the first time this matter is appearing for the first time, Your Lordship. The reference notice has been served upon the respondents, which is the annexure H of my petition in page 58, Your Lordship. Earlier occasion, another arbitration petition was filed, Your Lordship. But by an order dated 24th of March 2024, Honorable Justice Municipal had directed us to file same fresh notice as as per the direction it was complied by, which would be reflected in page 58 of my petition, Your Lordship. 16 July 2022, Your Lordship, the fresh reference notice has been. And that has been received, that is also annexed here with petition, Your Lordship. Refused return to the sender, refused return to the sender. Page 63, Your Lordship. That has been refused. Everything not available, page 65. The second respondent, your lordship, return to the center. So,
Where is the fourth order?
the court's order is in page 48 of my petition, your lordship. Annexure A. Lordship, what has happened is in this matter is that your lordship, the present petitioners, they are the 64%, approximately 60.
48 is order passed under 34
Yes, your lordship.
and this is under section 11.
This is under section 11, your lordship. Earlier, in page 42, your lordship, the first appointment of arbitrator reference letter, and subsequently it was filed and
No, if there is already an order under 34, why fresh application under section 11 has been made?
because that has not been complied with, your lordship, and for that section 11(6), this petition has been filed, your lordship.
This page 48 has not been complied.
No, your lordship. What has happened, your lordship, in the year 2020, the petitioners and the respondents, they came to a partnership, your lordship, where running of a nursing home, lordship, and subsequently they came to an agreement by the way, partnership dated of July 2020, your lordship. And all of us sat in your lordship on 2nd of May 2021, the respondent number 1, your lordship, he forcefully entered into the who is the partner of the firm.
No, why you have invoked section 11? I'm unable to understand why this application has been filed when there is an application under 34 of the arbitration and qualification.
Section 9, your lordship.
Yes, before appointment of arbitrator.
Before appointment.
For interim order.
Each order.
Any order was passed.
That is the that is the means judicial arbitration case is in page 35, your lordship, that is annexure D. Judicial arbitration, your lordship, the letter was said, and subsequent to that, section 9 proceedings started, your lordship, and at that time.
This was section 9 was filed by you.
Yes, your lordship. The clause, page 26, your lordship, the arbitration clause.
So they were restrained from obstructing.
Yes, your lordship.
Then what happened? That was assailed under section 34.
No, that was confirmed, but still they have not been able to enter the premises, and we are, even if we are the shareholder almost 64% of the nursing home, we are not getting any profit of the nursing home, we are not being able to enter the premises, your lordship. Hence this application under 11(6) of the arbitration.
Is all right, but why this order has been passed under at page 48? That is what I'm trying to understand. This is at whose instance?
It is a 48 is at the respondent's end, your lordship. This arbitration case number 23 is on their instance, your lordship.
Miscellaneous case 23.
Yes.
So they had challenged the order passed under section 9.
Yes, your lordship.
And what happened in that case?
Have appointed. So in that, they within 30 days from that, the notice of letter come in the such a. The entire document of the statement such can be submitted for the arbitrator. That was the decision. Subsequently, they came before this honorable court, filing and CO, your lordship.
Now, where is that order?
Page 52, they had come for an appeal. And page 51, they had come for a CO. Divisional application that was dismissed on the ground that it was not maintainable, your lordship. And page 52, they had come under HMAT, ERDA, Jalpaiguri. And in that also, your lordship.
Allow me to go through this. Let me go through, I'll take up tomorrow. Want to see all the orders, not. Timber, not. Last case. That was the last case. But you did not mention that on your motion it was sent to
Lordship,
Calcutta.
actually, I sent the email on that only.
But you did not mention this, sir.
Lordship, I was not even aware of.
It is your email.
Lordship, I understand.
Yes.
When I went to the last week before this circuit, when I went to Calcutta, I mentioned this matter in chief court. To
Yes.
constitute the bench so that I can move that application. It was
Yes.
told to me that lordships were coming here. So you don't mention go there, you mention there. So that's why last Wednesday I mentioned here.
But in the meantime, you have sent an email. On that email
Lordship,
basis, the file has
Lordship,
gone to Calcutta already.
I understand, Lordship. Now, kindly, if your Lordship take it on at least on Friday. It's only for recall.
We have taken steps, don't worry. Let's see what happens.
Lordship, shall I find the
Not required.
Lordship?
No slip is not required. We have already.
I'll get.
Yes, any other mentioning?
No, madam.
Yes, call.
Number one. Habeas corpus.
My lord, this is my matter, my lord.
Gave you a copy of that report, na?
Yes, my lord.
Oh, no.
Lordship, as per our report, anticipation report, the person for whom the habeas corpus.
Yes, we have seen that. Yesterday you filed.
Corpus custody.
Now you have to take steps, whatever you want to do.
My lord, only one thing, my lord, I have understood already. Kindly peruse, my lord, last 3 pages of the report, my lord. Kindly, my lord, for my satisfaction, my lord. I
No,
will
not for
waste-
your satisfaction. If it is for the client's benefit, you tell us.
My lord,
Yes,
the thing
for
is
learned
that,
counsel
my
for the
lord,
petitioner and the learned
my lord,
counsel.
kindly record my submission that he has been abducted by SSB on 7.
Alright, as well as
And he
the
has
learned
been,
counsel for the respondents. The habeas corpus application has been filed by alleging that the petitioner's husband was.
petitioner number 1's husband, my lord. Petitioner number 2 is the employee of the petitioner.
We have seen it. Don't prompt. that
My
the-
lord, I'm
that
extremely
the
sorry.
petitioner's husband was taken away forcibly by some SSB officials. Stop. They have also alleged was made allegation against 2 persons by name in the writ petition. When the matter was called on yesterday, the learned counsel representing the Union of India handed over a communication from the Commandant 41st Battalion SSB Rani Danga dated 24/4/2025, which discloses, which contains a copy of the FIR and press release issued in Nepal, full stop. The communication intimates the court the fact that an FIR has been lodged by the police in Nepal, wherein the petition number 1's husband was taken in custody on allegation of smuggling brown sugar, full stop. The report containing details of the FIR and press release containing the details of the petition number 1's husband being taken in custody by the police in Nepal have been handed over to the learned counsel for the writ petitioner, full stop. In view of this, in view of the information regarding the petitioner's arrest, as above, the learned counsel for the petitioner submits that now they will take appropriate action in accordance with law.
States
Stop.
kept of the record.
Huh?
States report also kept of
The state's, with such liberty, the writ petition is dismissed. Upar mein likh lena, the state has also submitted a report. Same thing.
What's the state government has taken state, that only is reflected.
State's report is taken on record.
I'm grateful to you.
Yes.
2 copies.
Maybe a copy will solve the matter.
Give a copy.
Name of. For your future reference. Number 2.
Lordship, the gentleman, what were
You had heard, yes.
Right, you have given us a copy of the act. I see your lordship.
Which was, what are the relevant, just give the relevant.
no prior permission?
Requirements under the statute
Yes, how much has been built? It was in accordance.
in accordance, but the only thing is that there is no prior permission under which provision. Arising in the case.
273. 63. 60, I think, no, 63, lordship. 263. Sanction or provisional sanction or refusal of sanction for erection of building work. 8 with lordship. Section.
263 of the municipal building rules.
No, Corporation Act. Add to that, I would let me take your lordship to section 261A. 261A provision of no sanction.
It's a residential building.
Yes, sir.
And the demolition order has been passed under which provision?
68. 68, right with lordship, 287. 68, right with 287.
Two 68 read with?
287, unauthorized construction.
We have taken a very
So did you give him a notice under 287?
Oh, straight. Straight around the world. No.
Does 287 contemplate giving of a notice?
Yes. You have to,
So the penal provision contains a procedure, it has to be complied or not complied?
yes, just to 287 request, after giving the owner of the building
A reasonable opportunity of being heard. You have not done this.
Now, the thing is that we had, the commissioner had sought for approval, opinion from the UDMA department. UDMA department said that it cannot be.
UDMA.
State government, Urban Development and Municipal Affairs Department. Now, they stated that this cannot be done. So accordingly, in terms of their order, we have given them a notice that your prayer for your application has been rejected, and subsequently, a notice was given to them for.
So first his application for sanction has been rejected.
No, that was not. He had applied in the portal. While it was being checked, thereafter, it was found that before the.
Can you give a few dates? What is the date of his application?
Yes, his application date is 20th April 2023. If your lordship takes my list of dates,
It is detailed.
yes.
My lord, I'm appearing in item number 3, my lord. I'm appearing in item number 3, my lord.
220.
So 14/8/24, there is a confirmation, and 26/9/24 is the intimation sent. Where are these two documents?
26/9 document is lordship at page number 28. Page 28, lordship. And with regard to 14th August 14/8, it is at page 24.
Hmm. What is the date of commencement of work by him? According to you?
According to your lordship,
Have you said anything on this point or?
yes, yes. In paragraph number 6, 6, I have stated that in the meantime, in the month of May 2024, somehow it came to the notice of Siliguri Municipal Corporation that the owner of the respondent herein commenced the construction activity in the said plot without getting the approved building plan. Came to our
May
May 2024.
24.
24, May 2024.
So more than a year after he applied. He applied for sanction in April 23.
Yeah. No. It is May 2023.
May 23. Why have you challenged an interim order? The issue could very well be decided there.
The interim order stated that directed the corporation to take steps in terms of our decision dated 18th November, 18th November 2023. In that decision, it was decided that penalty would be collected from him and given him permission. Since that decision itself is not.
Where is the 18 November decision?
The page. There's 21. 20.
What is 400?
Calcutta Municipal offer that. It's not near.
Oh.
Calcutta Municipal offer.
400 referred to in that is regarding Calcutta Municipal Corporation.
I booked.
So how that will apply?
T73A is there is a section. It minor. 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 वो just step. Actually. Well, no. 400 is given the ACMA. He's coming back, then I see the code. Well, 268. Well, that. Yes. This is
Yes. Yes. Evaluation. To see, one of the third provides is applicable here. Maybe. Okay. This section is 373A, my lord. Section.
Yes, but in section 287, nothing has been mentioned about regularizing the. That is only. That is only difficulty. This guy admit this is wrong.
The section is there. 373A, they can do. I assist the court one.
Lordship takes 373A, section 373.
Now it is all.
No. But if I had to take reports of section of 400 of the KMC Act, I had to obtain prior permission of the state government. Which I have not done. Yes.
The new act also there, or is given by now rules. Just.
Not without.
No, new rules, there are new provisions come, they can do it. Rules, West Bengal, Municipal Building Rule 2007. Is your lordship, my lord. That same provision is inserted in the rules also now, for applicable to the, they have not taken into consideration, but I just had to do. The rules is your lordship, my lord. The West Bengal Municipal Building Rules 2007. 30, can you think of 32? Second proviso. They have provided further that Board of Council may by order of regulation, regulate minor unauthorized erection, execute any minor work with a sanction under these rules, minor deviation from the sanction, plan or execute any minor erection work in conformity to any sanction plan under this rule, keeping regard to the following things as the case may be, fees, charges. Second, my lord, your books is not, my lord, amended. Can you see this? Subsequent amendment. It's very well. Yeah, all right, we will say. It was just. And my, no, was any? But I saw, can you see? Sorry, my lord, I had two books. তিনটা আনতে বলি সবসময় কেন বলছি বই নিয়ে রুলস ভালো তো রুলস ছাড়া yes. Without looking into that, they have sent it back, but they have, honorable signature says they distort the fact. They have not brought to state government that it is in their knowledge.
Lordship, provided that the Board of Councillors may by order regularize the minor unauthorized instruction or execution of the minor work without sanction under this, without the covers.
That was one of the things I just did. So instead of 400,
Lordship.
clarify including the rule 32.
Lordship.
Second voice.
Forget the 432, that will be. What is your difference?
Identical provision has come. Well, different provision of the religion. This is the third provision of 400 equivalent provision.
Minor work without time, was the lodge. Area of the area. Yes. That can be regulated.
Yes.
So you can see the action with regard to the 400 this.
Lordship.
For example, 32 of the.
Municipal building rules, municipal building rules, 2007. Lordship.
Application stands disposed of. What was the application for? Stay.
One is my lord's voice is not audible, but I think maybe the microphone is not on.
My lord, item number 3, my lord.
Yes, so it will be in the same terms.
Yes, sir, the same terms. I'm just placing my lord page number 16 of the stay application.
Just wait.
It takes up the by synopsis and list of dates at the front. The lordship will get the same. Only the dates will change, otherwise. Well, I feel the order.
The corporation resolution is of the same date.
Same, my lord.
Put the matters were taken, put them considered.
This newly added provision was already there when you had issued the notice in September.
And my lord, since your lordship has already pointed out, my lord, and passed an order in earlier my lord, matter, but my lord, to supplement one thing, my lord,
Yes.
my lord, if your lordship consider section 266 once, my lord, find that as per the West Bengal Municipal Corporation Act, all unauthorized my lord, building did not demand my lord, the demolition. There is a discretionary power. The word used is may. And my lord, there is a provision of fine that is already in the my lord, statute in Schedule 5. I'm just pointing out, my lord, because lordship has already passed an order, but just to my lord, point out, my lord. Lordship kindly consider section 266 once.
That's 266.
My lord, find that where the erection of any building or execution of any work has been commenced or is being carried on or has been completed without or contrary to the sanction referred to in section 263 or in contravention of any of the provisions of this act or the rules and the regulation made thereunder, comma, the commissioner may, I'm just requesting my lord to stress on this word may, in addition to any other action that may be taken under this act, make an order directing that such erection or work shall be demolished by the person as whose instance the erection or the work has been commenced or being carried on or being completed within such period not being less than 5 days or more than 15 days from the date on which the copy of the order of demolition with a brief statement of reasons therefore has been delivered to such person as may be specified in the order. Now, if your lordship consider this particular portion of the section, my lord kindly emphasize on two words. One is may in addition to, and secondly, the brief statement of reason. So, my lord, this particular section empowers the commissioner a discretionary power that he may direct for demolition or he may my lord, direct for payment of fine, which is at my lord, kindly consider Schedule 5 of the Act. Schedule 5 of the Act wherein your lordship considers section 266. But I think it's in fourth page, Schedule 5, fourth page, lordship find. Fourth page top.
Schedule 5.
Schedule 5, fourth page top, subsection.
Page 280.
Lordship at the top, my lord find section 266, subsection 1. That is, my lord, the question of the power of the commissioner against the unauthorized construction. Now, the second part, unauthorized erection of a building, 2,500 rupees or imprisonment for 6 months or both, and daily fine is 200 rupees. So, this particular act itself empowers the commissioner to use the discretionary power either to demolish or to impose fine. And that is the reason the legislature in his wisdom stated in the section itself, the word used, the brief statement of the reason why the building deserved to be demolished or why the building is to be regularized by way of imposing fine, that part is already there in section 266. That is what I want to just supplement. Malad is not audible, Malad.
These provision which he is relying upon, Schedule 5 specifies the penalties which are imposed under Section 384. Now, these are penal provisions. So, this is must be subject to some proceedings, pursuant to which the penalty is awarded.
Malad, that is in the very next part of the 266, very next part. Provided that no order of demolition shall be made unless such person has given by means of a notice served in such manner as the commissioner may think fit, a reasonable opportunity of showing cause why such order shall not be made. So,
No, sir, there must be a procedure for this. Can't be what you are reading, cannot be. Yes,
This penalty for breach of regulation.
correct.
These regulation made under this act, they provide contravention, they provide other contravention, therefore, the punishable is fine, which may be 2,500 rupees or which may be 2,000 rupees.
No, but where are the procedure, where this proceeding is conducted, by which authority? Who conducts the penal proceedings?
Malad, the 384 Malad, section 384 says the penalty provision.
Yes.
Chapter 25.
There is a penal procedure and there is a penal provision and there is a procedural provision. Where is the procedural aspect for imposition of such penalty?
Malad, my humble submission, Malad, the act remains
You have
silent.
said 266.
Yes, Malad, what I am trying to convey, my lord, that
266 is a different, that is not doesn't appear to be. There must be a procedure for imposition of these penalties.
Malad, Malad, the reason for referring 266 will, Malad, that Schedule 5.
In 263, the municipal corporation, the commissioner can direct 6 months imprisonment.
Malad, I find in the Malad, because in the earlier
Can it be?
Malad, I tell your lordship, Malad, in earlier Kolkata Municipal Corporation Act, Malad, there is a power, Malad, vested to the magistrate. The corporation.
Correct. Therefore, when there is a penal provision which entails
Exactly,
incarceration, it can be passed by the municipal commissioner. Cannot be.
Malad, I tell you, lordship, Malad, yesterday I have gone through this, Malad.
Yes.
In 1951 Act of Kolkata Municipal Corporation, the commissioner referred the matter before the magistrate who can impose, Malad, this proceeding. But in this particular act, Malad, there is no, I find, Malad, there is no such provision, Malad, in this particular act. Though, Malad, the penal provision is there.
So therefore, if there is no procedure, maybe, I have not gone through the entire act, there must be some procedure somewhere. Then that penalty cannot be imposed by the commissioner in absence of any procedure. So that this schedule that you are relying upon, it is in furtherance of 384. Just see at the top of the schedule what it says.
Yes, Malad. That is in furtherance of the.
Penalties, these are penalties under section 384. So these penalties cannot be imposed by the commissioner. If it is to be read that way, then the commissioner would have power to sentence you to 6 months imprisonment also.
But Malad, what I am Malad trying to satisfy Malad, that the imposition of fine.
This is not a fine. This is a penal provision. This is not a condonation or regularization provision. For that, the second proviso may apply of the amended rules of 7/7.
Yes, Malad, that is there.
2020.
Malad. That is there. That is there,
only.
Malad.
There is no procedure for imposing these penalties.
Because Malad, present Malad Kolkata Municipal Corporation Act, Malad Bengal Municipal Act, as well as Malad in the Bengal Municipal Corporation Act, Malad. So far as Malad, I have gone through the Malad those acts, Malad. There is no such provision empowering any magistrate to impose Malad the imprisonment or anything, Malad. Though Malad there is a power Malad to impose fine.
It can't be, sir. Has to be somewhere. Now come to 395, please. Section 395.
Cognizance of offences. All offences under this act or rules or regulations made hereunder, whether committed within or outside the corporation area, shall be cognizable by a judicial magistrate.
Correct. So this schedule 5 is for those are penalties.
Yes, my lord. Yes.
So therefore, it will be the same, more or less the same order.
Same order, my lord. Said, I just want to supplement this.
No, it is good that you have pointed out, but then this appears to be 384 contains the penalties for the offences. Offences are cognizable by a magistrate under 395. So all the penalties specified in Schedule 5, they are to be applied by a magistrate once he has taken cognizance of offences under the Act. So that cannot be discharged by the commissioner. Therefore, I said there must be a provision. How it can be that the statute will not have a provision?
I'm sorry, my lord. I should have pointed out, my lord.
Therefore, schedule says at the top. The section 3. By the magistrate, not by the commissioner. So if there is no distinction, will in the same terms, where is the list of dates? Let us see. Let's finish the order here itself. Otherwise, it will.
My lord, page 16, lordship fine, my lord, from the stay application. This is the demand.
What we'll do is we'll take this up after recess. In the meantime, we'll get the draft of the other order. So that will facilitate passing of the order. We'll take note of this
As your lordship, sir.
after recess. Yes. It is that council spoke after some.
For the private restaurant, sir.
Lordship, last occasion, my lord had opined that no report is necessary because it's a very simple matter. It's about this, my lord, may I come?
We'll have to refresh.
No, my lord, that is my duty. Lord, a writ petition was brought out by the appellants before my lords,
Yes. For?
challenging an order passed by the assistant tahsildar for demolition of the structures in Matigara Hut.
By the which authority?
Assistant tahsildar.
Tehsildar. NHAI.
No, my lord. It's DI fund.
Huh?
DI, District Improvement Trust Fund.
Okay.
But actually, there were certain specific huts created under the DI fund, which is now almost obsolete, which is under the direct control of the district magistrate. And my lord knows that most of the lands, almost all the lands are under the control of the BLRO or the DLRO. The name, the person may be the same, but the designation is different, my lord. Most of the lands are controlled, managed by the DLRO. Certain portions of land, particularly in Darjeeling district, and maybe in one or two places in then Bangladesh, which is part of India at that time, it came under the DI fund and district under direct control of the district magistrate.
This fund is under which provision?
There is a different act, my lord, DI fund. DI fund rules.
There are rules.
So, my lord,
No, it is, I am finding this for the first time. I would like to see, therefore I am asking.
act rules.
Yes.
My lord, the rules has been annexed in the writ petition.
So it is there.
And it starts from page 17, P1.
Then?
But this was challenged. His lordship of the single bench disposed of the writ, holding that as point, if I take your lordship to the interim order.
This is a order passed by the single bench interim order.
No, my lord,
Final
order. And that has been challenged by this.
No, lordship. Kindly takes page 4 of the interim order.
18, 11, 20.
Lordship. My lord, has it?
Yes.
Second paragraph. It is pointed out by the learned advocate for the private respondent number 6 that in paragraph 8 of the writ petition, the petitioners themselves admitted that they have constructed pakka structures at their respective plots. Even assuming that the license was granted under rules 35 to 37, the petitioners have no authority to construct pakka structure over the land allotted to them. They are entitled to construct only temporary structures for their business purpose. Learned advocate for the respondent also draws my attention to the last paragraph of the order passed by the learned subdivision officer, wherein the petitioners were directed to unblock the drain, not to construct any pakka structures over the hut road, demolish pakka structures if any, and not to encroach any portion of the hut land. However, they may use open hut surface for paying tolls like season tickets / SR fees. My lord, now kindly considers the writ application filed by the petition.
So you want to construct pakka structure?
No, man. For the whole trade. It was held by this learned single bench that I have admitted in my pleading that I have.
No, therefore, even if you have not admitted, we are asking you, do you want to construct pakka
I
structure?
will be thrown out of my business.
Then
I cannot
what
by
is,
any means construct a pakka structure, I can have hutment.
So that is an admitted position. You cannot
I
construct.
can not,
You have not.
no.
So if you have not and you cannot, then how does this prejudice you?
My lord, because basing on this, he said demolish it. His lordship has said demolish it.
What will be demolished if there is no pakka structure?
My lord, this reasoning does not prevail with the executives. That is the
So
problem.
what will they
And another thing, my lord.
We are asking you, what is the prejudice caused to you? What do you stand to
We wanted
lose?
to get the order passed by assistant tehsil.
See,
set aside.
if there is no structure, then an admission has wrongly been recorded.
Yes, my lord.
Then nothing
My
is
lord,
there to be demolished.
My lord, I came to the court challenging the order of demolition passed by the assistant tehsildar, that I have to demolish the structures within 3 days.
Of permanent structures.
When notice was served upon me.
Obviously, that much we have understood by now.
So
You are carrying on some business under the rules. This plot is in your occupation
Yes.
since long.
Yes.
We have not gone through the provisions of the rule. Perhaps it contemplates that you can continue to
Yes.
carry on business. There must be some license fee or something
I'm paying
payable.
that.
You are paying that. Only issue is in the discharge of your livelihood, whether you have erected a permanent structure there or not.
No.
You say the Honorable Single Judge has wrongly recorded the admission because there is no scope for construction. We have not done it, nor we intend to do it.
But
Then what will be
but
demolished?
the assistant tehsildar's order is upon me, you demolish.
So you tell him that there is no structure to
My
be
lord,
demolished.
I only pray for setting aside that order.
Have you told him that there is no structure for being demolished?
My lord, within 3 days, how can I tell him? So I came.
We are asking you right now. You tell him that there is no
So my
permanent structure.
humble prayer would be, let this appeal be kept pending. Let me approach the tehsildar. I'll come back. Because I need some protection.
Sir, protection from what? That is what we are
From the
asking.
order of the
What?
assistant tehsildar.
An order which is incapable of execution. When there is no pakka structure to be demolished, what is your threat?
My lord, my learned friend is very agreeable to the proposition falling from the bench. Let him
I have not even turned to him. I am only asking you.
My lord, there was a specific order from the assistant tehsildar to demolish straight away.
Demolish what?
My structure.
What is the date of the demolition order?
My lord, it is
3rd October 2020.
no 31st October 2020.
Our order is now.
Yes, sir. What is the date?
31/10/2020.
31/10/20.
2020.
So 31/10/2020 asked you to demolish, or they said we will demolish.
Yes.
What? They asked you, or they said we will demolish?
It has been reported and on inquiry it is found that the SDO Siliguri had directed you to demolish the structure in occupation wide memo number 23 dated so and so. My lord, the order is,
Dated?
28/2/2020.
28/2.
Yes, sir. But
So
the SDO, learned SDO did not pass any such order. I will take that.
Anyway.
However, till date, we have blatantly failed and neglected to comply with the order given by the SDO of Office Siliguri. Hence, you are directed to demolish immediately within 3 days. This notice is a reminder to you to comply the said order, failing which you will be liable to face consequences of law.
So therefore, what was the big
No,
deal?
my
You
lord,
could go and tell him that there is no structure to be demolished.
Kindly takes the SDO's order. Yes.
There is no threatened demolition.
No.
He says you demolish.
But the threatened demolition could not take place because of the writ application and the subsequent appeal.
The notice does not threaten you with demolition. He says you demolish. He is not saying that failing which we will demolish.
Yes. Once consequences of law will
Consequences of law will follow. So you could have gone and told him that, look, there is no structure.
Then, my lord,
Did you respond to this notice?
my lord, allows me to respond to the notice. Till the decision is arrived by the assistant tehsildar or the SDO, I may be protected that nothing no more.
Sir, your no, yes does not make any difference. Please sit down. Please, we'll call upon you. Yes. That is why we are repeatedly asking you, what is the threat? The court's order is not only to be passed for the asking. Unless there is a threat, you say that admission is wrongly recorded, But then you're, in
My-
the same breath,
second-
you
second
say
point
there
that
is,
my lord, let me-
yes.
Is the SDO who is the controlling of the authority upon which the assistant Tahsildar has issued the notice under challenge. He did not ask us to demolish.
That's besides the point. The
No, my lord,
point
he
is why,
is referring to that order, assistant Tahsildar.
whatever it is,
So that
if
order
there
did
is no
not-
structure, then what is wrong with the single judge order? That is all we are asking you.
My lord, the single judge did not give any finding whether my structure was pakka.
No, the single judge says that
I
admitted
have
position
admitted.
is that there is no structure.
No. Respondent number 6, just now who was asked to sit down, my lord. He
The
pointed out to
single
the court
judge-
that there is I have pleaded that I have created
The writ petitioners themselves have admitted that their
Yes.
respective plots, even assuming that license was granted so and so constructed,
But
they are
we have
entitled to
not made any
construct
such-
only temporary structures for their business
But my-
purpose.
the writ petition, there was no such allegation.
In your writ petition, have you annexed a photograph of your structure?
No, my lord. In paragraph 8, there was no such statement made.
Have you annexed a photograph in support of your, where is your averment?
Yes,
In the writ petition, where have you said that there is no permanent structure? Just show that averment.
Then,
Show the averment in the writ petition that there is no permanent structure.
lordship. May I read from the writ?
Which paragraph?
Lordship 6, 7, 8.
Writ petition. No, this is your can. We are asking you to show from the writ petition.
My lord, it is in the MAT file, my lord.
MAT file, memorandum.
Yes, my lord. একটা দাঁড়াও না, annex একটা বলতে দাও। যেটা check code সেটা দিতে হবে। Lord, my lord, just after the impugned order.
Paragraph 6, 7 and 8.
My lord, page 5. May I read out? The petitioners are carrying on their business in their respective places for more than 40 years without any complaint from any corner. The petitioners obtained trade license, season tickets, permissions from the Gram Panchayat from the concerned authorities. The petitioners have been paying taxes to the concerned department regularly. Copies of the trade license, season tickets, permissions for concerned authority and tax fees are annexed to and marked collectively as Annexure P2. Structures of most of the stalls in Matigara Hut was and is semi-pakka with wooden planks thatched with tin roof without having any limit of maximum height. Most of these structures of stalls are owned by stall holders. Naturally, such types of structures of stalls did not have any longevity. By efflux of time, structures of those shops became dilapidated. As a consequence thereof, renovation and repairing of those age-old structures of stalls are being required frequently for maintenance and structural safety. As such, petitioners have constructed semi-pakka temporary structures and or gumtis at their respective plots without any deviation and extension and upon priority intimation to the concerned respondents. However, the authorities have always refused to acknowledge the said prior intimation.
So there are many petitioners.
4, 5.
Where is P8?
8.
Annexure P8. Don't annex the entire writ petition, that is the problem. Difficult to find. And then everything you annex in a can or a stay application. So there is repetition.
This is a GL.
There is a repetition of everything in the
Everything, my
record, making it more difficult for the court. Please find the notice of 310, 3110. We will be back after this. Yes.
Also, page 63, madam.
63.
Actually, it is just this replica of the 31st notice. It is same issued by the assistant Tehsildar. My lord had seen the page 66, 31/10/2020 notice. It is the same, my lord, a copy. Same language. 3-paragraph notice as it was served on 31/10/2020.
3110. This is 310.
This is 310, my lord, and 3110, both are same, perimetry. Line by line, word by word, same.
30th also they have given you notice. So 3 notices.
Lots of.
In that 1 month period, they have given you 3 notices. But you did not do anything. Neither you responded nor you demolished.
No, my lord.
So,
I came to the honorable court.
no, for 1 month you didn't do anything. From 3rd October to 31st October, you didn't do anything.
No, my lord, just let me check out the date of filing of the writ.
Because the annexure is there, it must be after 31st.
No, my lord, we came before the honorable court on 5th of October 2020.
Then how the annexure is there? 3110.
They issued it.
You have shown this page.
310, 310.
310. After 310, you came to the court. So, where is the writ petition?
Writ petition starts, my lord, at MAT file. You lordship will find it. From page. Just after the impugned order, lordship.
It's not there. After the impugned order, it is there is.
My lord, is the MAT file. Perhaps is looking into the CAN application. Lordship has it?
Yes. Prior to this also, you had come to the writ court.
My lord, the respondent number 6 had gone to the writ. The respondent number, private respondent, my lord, before your lordship, he had filed one writ application.
Private respondent.
Yes, my lord.
For?
My lord, that I don't have immediately, I may not be able to assist your lordship on that matter. But since there was a litigation, we had mentioned it in our writ. Actually, it was, my lord, if we can, if your lordship takes paragraph 12, the Honorable Justice Ladyship Musmuli Champa Sarkar had dealt with the litigation. However, I do not find any police inaction in the matter. The dispute is entirely civil in nature. As it appears that the petitioner has made a representation with the concerned assistant Tahsildar, having his office in the office of the block development officer, Matigara block, who has allegedly given the permission to both the petitioner and other persons to run shop rooms in the land belonging to Matigara DI Fundar. The said authority is directed to consider and dispose of the representation made by the learned advocate of the petitioner dated February 2018. While deciding the dispute, the said authority will hear the petitioner and other persons who have started their business in front of the shop room of the petitioner and pass a recent order in accordance with law. The entire exercise shall be completed by the concerned authority within a period of 6 weeks from the date of communication of this order. It is expected that the authority concerned shall make all endeavor to settle the dispute between the petitioner and the other persons in this regard, so that all parties can run their business without covering the frontage of the shop rooms. If required, the authorities shall make a spot inspection to see the position of the shop rooms upon notice to the concerned parties. My lord. May I, my lord?
Where is P7 of the
My
writ
lord,
petition?
P7 is page 61.
Now can application.
Matman.
61 of MAT.
Lordship.
MAT is only 45 pages.
Well, just give me 1 minute, I will find it out. My lord, takes the CAN application, page 41, my lord. Annexure E. E লিখে তো 40 না 41 না 50 তোমাকে বলি দিই।
You said 28-2 order was not served on you. You have annexed it in the writ petition.
28-2.
Yes, SDO's order. This is
No,
the SDO's.
28-2 order is coming out for the first time now.
This is the SDO's order which was referred to by the
Yes, my
Tahsildar.
lord, we never said that it was not served upon us.
No, in the first half you were saying
No,
this,
but-
we don't have this order.
We have. I was trying to take your lordship's attention to this very order. Because in pursuance of the order passed by the Honorable Court, this inquiry was done. And what was the inquiry findings given that I wanted to show to you. My lord may come to the finally as per. May I read out, my lord? Can I দেখুন, can I? No.
You are Uttam Datta.
Uttam Datta. Dilip Sinha Rai, Ratan Datta, Pramod Gupta, and Anjana Das. 5 persons are before me.
No, but they are all claiming through Uttam Datta only.
No, my lord, they are separate. Uttam Datta is the petitioner number 1 before the writ order. The other five, Sri Bhanu Datta, Ratan Datta, Sri Pramod Gupta, Sri Dilip Sinha, Anjana Das, are paying toll like SR fees and season tickets, which is used to be imposed to the vendors for using open space or open hard surface on DI fund. Finally, as per report submitted by Assistant Tehsildar, DI fund had white memo number so and so, after spot inspection of said area, it is found that Sri Torun Kumar Shah has been using the original pathway which is on the post office side as the main entrance, and there is restriction in ingress or egress to his property. Hence, Sri Shah is directed to use his original pathway which he has been using since long as the main entrance. He is also directed to seek permission for all the shop constructions emailed in writing and submitting prescribed fees openly, properly. The other parties, namely Bhanu Datta, Ratan Datta, Pramod Gupta, Vishnu Charan Gupta, they are not, my lord, are hereby directed to unblock the drain, not to construct any pakka structure over the Hart Road, demolish pakka structure if any. So even on the date of passing of the order, there was no finding that the petitioners has constructed any pakka structures. After that, the assistant tehsildar suddenly going against his own finding became overzealous and issued the notice dated 3/10/2012.
But nothing has happened till now.
Because we came before the honorable court.
But there is no interim order.
No interim order.
So therefore, again, we are saying if there is no pakka structure, what is your apprehension? What is your apprehension or threat? That's what we fail to understand.
My lord, there was no finding in the SDO's report that I have constructed any pakka structure. It was upon the spot verification report of the same person who has asked me to demolish my structure, now holding it to be a pakka structure within 3 days.
That demolition order is
310, my lord.
310.
P8, page 63 of the MAT.
60.
Or
how you are making submitting regarding the paging, we don't know. We are absolutely clueless.
Actually, my lord, I
There
also
is
sometimes
the
get
mat is only of 5 pages. That's all. You are saying 45, 61 from mat.
My lord, MAT 56 of 2021.
Correct. It's a 5-page appeal, memorandum of appeal, nothing.
ওখানে তো নেই না
How do you file such cases? Really,
My lord,
it should be
actually,
your zeal to see that the things are convenient for the bench to understand.
My lord,
I
this
don't know how
file-
the client will benefit if
No,
you,
my lord,
this is the way you are
actually,
filing.
did not supervise the filing of this.
So whoever it is, we are not telling you. How do they file like this?
But I got this, my lord, I also found it very difficult to follow in the evenings.
Should impose cost on the person who files like this. This is the way to file a case. Nobody will take responsibility, then pay the cost. The petitioner should pay the cost.
My lord, it is Mr. Dhar who filed the appeal.
We don't know. We are not going to run after anyone.
Because he is still in his name in the cause list.
And you are appearing, you must take the responsibility. You can't shift it on
No,
someone
I am
else.
not shifting it, but since your lordship inquired, I also.
We didn't inquire anything. We say, how do you expect the court to follow
It is
whatever
very
you are
difficult, my lord.
spending
My
half
lord,
an
then,
hour
my-
just
my
trying
lord-
to search for the,
my lord-
where is the, show the order 310. After so much time now, we don't want to adjourn it for such
my
silly
lord,
reason.
The page editing is not matching, my lord, with my page editing. That is the problem. P8, my lord, has just seen before the recess, your lordship rose. P8.
Yes, to that effect, he appears to be correct. You are for the corporation. Who is for the corporation? Yes.
The state.
Yes, whoever it is, this assistant tehsildar, you must be representing. What is that you want him to demolish? You say as per 28 to, come to 28 to order. Where is the finding? What is to be demolished? Yes, if any, if any. So what is he? Where is that finding?
The earlier report as filed for sound report.
Where is that?
Dated 8th of April, 21st report.
8th of April.
Only to the extent of one petitioner.
Hmm? Let's see the report. This thing is filed a report.
Well, there is a report from the state.
The file is in such a mess, impossible to consider any. Where is the report? I can't. No.
Well, there was a report filed by the state, but your lordship indicated that your lordship would go on the. That's it.
There you go.
Now let us see the provisions of the rules regarding management of the improvement fund first. Where is the provision regarding granting of patta or license, whatever it is?
Lordship.
Now, Anish, my copy of the candidate there.
It is your law.
Oh, but go ahead.
But it starts from 36, 37 onwards. Last year's found it.
No, perhaps it starts from 37 is what?
37, a Tahsildar or assistant Tahsildar shall grant a receipt in form of 32 to a person making a payment on account of ground rent, cess, conservancy tax, salami or any other miscellaneous item. Then Malat come to rule relating to bungalows, then some relevance is found in rule 43, my lord.
And who is the administrator?
SDO. My lord, I stand corrected. My lord, kindly takes chapter 2, rules relating to hearts and bazaars. Lordship has
Deputy Commissioner is the administrator, not the subdivisional officer.
My lord, also any gazetted officer subordinate to him.
Yes. So this is a major in the one of the major charges, Matigara.
Yes.
There are two kinds of hearts.
Yes, my lord. My major and minor.
Major and minor. This is a major one.
That's it.
So this will fall under the Tehsildar.
Yes, my lord.
The minor will fall under Assistant Tehsildar.
Yes, but in some cases, the assistant Tehsildar may be asked to look into a major heart. That is also there. But my lord, for the persons who are dealing in business like the petitioner, I could not come across any fixed provision in the rules which they can be pinned down. That you cannot do this, you can do this. Nothing is there, my lord.
When there is no provision in this rules for erecting any structure, can any structure be erected? In the provisions regarding haats and bazaars, there is no provision regarding any structure. It says lease of the land only. A hart is a very well-known concept in 1923 when this rule came into force. The harts were just thellas and vendors and all that.
Mostly open.
Open. So therefore, there is no question of any structure.
They'll produce, sit on the.
Hart was just sitting squat there with your produce, sell and go.
But subsequently, my lord, because my lord.
That development, there is no scope
No, my
under the
lord, I'm
rules.
coming to that because this hart had a different character because it was the hub of jute trade.
Whatever it is,
No,
under
my
the
lord.
rule, there is no such a scope.
Yes, there is nothing that says what structure cannot be erected also.
When there is no provision for erection, where is the question of any prohibition?
I can.
Where it needs, where the rule wants to talk about structures, it does.
It does.
There is a specific provision for bungalows and all that. Where in the hart provision, there is no such a scope whatsoever. It is just a lease or a settlement for that particular land, that's all. There is no question of erection of any kind of a structure thereon. So therefore, there is no question of any permanent structure.
Can. If he is given an allotment, he can, because there is certain provisions that is extension of holding. So extension of holding.
Extension does not mean structure. Extension means increasing the size of the holding. So instead of 20 feet, it may become 40.
And there is also, my lord, shares by whom to be done.
Yes.
So repair of land cannot be done, my lord. Repair of a structure can be done.
Let's see, where is that repairs?
No, my lord, this is two different things.
That's what we are saying. That is rules relating to bungalows.
Yes,
in the earlier provision, the earlier chapter 2, there is no mention of any structure whatsoever.
Either temporary or permanent.
Either temporary or permanent. But temporary would not be a structure to begin with because it would not be in any way. It can be just removed in a day. And there is a provision of appeal also under this rules. Why have you not gone in appeal? Why have you come to the High Court without availing the statutory remedy of appeal? Before the administrator.
Appeal against any penalty imposed.
So this is a penal provision asking you to demolish. What more is?
I'm on the different footing.
Yes.
The penalty imposed shall lie to the penalty is very specifically given what should be the penalty.
Where is the penalty specific?
Penalty by whom is to be inflicted? Penalty for not registering the lease. A person failing to register 4 annas, that is pecuniary penalty, my lord.
So appeal is only for
pecuniary penalty.
All right.
For living fines, charges, whatever.
Very well. Otherwise, there is no provision of appeal.
No remedy as such.
But now there is a finding, there is a report that there is a structure.
Yes, with respect to only one petition.
Whoever it is.
No, my lord, the report is very clear. Who has constructed, who hasn't.
Yes.
Lordship will see that it is clearly written. During inquiry, it revealed that Uttam Datta Uttam Datta has erected a permanent structure.
No. Dilip Singha, Ratan Datta, Pramod Gupta and Srimati Anjana Das has erected temporary structure of galvanized corrugated sheet walls and roof with wooden bamboo frame. And Uttam has erected permanent structure.
So Uttam is within the red tape. Because the question is I cannot raise a permanent structure.
So who is, you are representing Uttam also?
Petitioner number 1.
So regarding the others, then there is no scope. What temporary structure?
The galvanized corrugated walls and roof with wooden bamboo frame.
No, but the order of the SDO is very clear. To demolish permanent structure, if any. It is not for temporary structure. If you go for temporary structure, the petitioner of earlier writ petition may also land in hot soup. Yes.
And he has already rendered, my lord, in this report, because it is
Therefore,
found that he is in.
for the other petitioners, there is nothing. In view of your report, you proceed against this person. He will avail his remedies, whatever he has to avail. You can challenge this report if you want, before any authority you want.
There is no forum to challenge this report.
Therefore, you can challenge this report. That's why we are saying.
So I have to come up with another writ application.
Therefore, that we don't want to say.
No, my lord,
You decide.
my
what
lord,
you-
if I press further, my lord will say, let me retire and come to me for advice.
Therefore, you have to go there. So therefore, nothing remains for the others. Yes, what do you have to say now?
Right? That's all. Like, very good, that's so good.
Anyway, he will deal with that. He will deal with that. We are not here to say anything. So regarding the other petitioners, there is nothing. Regarding this person, petition number 1, we will give him liberty to assail this order in appropriate proceedings in accordance with law. So nothing survives. So
Only, my lord, since my lord was indicating that I should go before the assistant Tahsildar, challenging his 31020 notice.
no. We never said that. We said you go and appeal.
There is no appeal, my lord.
But you said there is no appeal, so there is no question of appeal. So we leave it open to you whether you assail it in whichever proceeding you want. Whatever is after a thorough study, we don't know whether there is any precedent, subsequently any rule, regulation has been framed
No,
under
my
this.
lord. No, that is the only.
We are not aware. So we don't want to limit your, we'll leave it open to assail this in whatever.
But my lord,
proceeding.
what about the rest of the petitioners? Their writ was thrown out by the learned, sir.
But now nothing remains in view of this report. This report only says some temporary structure about them. So
As my lord, then that 3rd October 2020 notice is infructuous.
obviously it is infructuous for all excepting you, for petition number 1. Because 310 says in light of the SDO's order, and SDO says permanent structure if any. Okay.
The lordship is kind enough to indicate that much. That would suffice.
We'll have to. Just again now we'll have to look for both these documents.
Lordship, if my lord permits, I can hand over from my brief.
No, we'll just find it. Very difficult to. 310 is at page 60.
66, my lord.
363 in our brief.
My lord.
Impossible.
And prior to that, 61 is SDO's order.
61, no, not in our brief. SDO's order is in the mat.
Mat, my lord.
Page 41. It's page 41 of the mat. It is of 28 to 20.
Lordship.
Demolish pakka structure if any. That's a very clear direction.
Can use the art by taking the seasonal.
That we are not going to say on about anything else. Only insofar as the demolition aspect. He is not aggrieved by levy of what you are charging and all that. He is only aggrieved by the demolition aspect. He says there was no finding how he has directed. Yes, take down. The writ petitioners were served with a notice dated 3/10/2020 by the Assistant Tahsildar, Matigara Hat. The notice was alleging that the writ petitioners neglected to comply with the order given by the SDO Siliguri under memo number 23 dash slash within bracket 6/DIF capitals dated 28/2/2020. Stop. Since the petitioners failed to comply with the said order, they were directed by the Assistant Tehsildar to demolish immediately within 3 days the structures as were required to be demolished under the order of the subdivisional officer dated 28/2/2020. Since the demolition has been directed in purported compliance of the findings arrived at by the subdivisional officer in his order dated 28/2/2020, we deem it appropriate to reproduce relevant extract of the order passed by the subdivisional officer, which reads as follows. Page 41 of Can 2, I think. Can 2. The senior counsel for the petitioner submits that the notice issued by the Tehsildar was unsustainable, full stop. The order of the subdivisional officer dated 28/2/2020 did not record any definite finding regarding there being any pakka structure erected by any of the writ petitioners. The order directed for unblocking of the drain, not to construct any pakka structure over the Hart Road, and proceeded to pass Number I don't know. This is MAT2. You are pointing out the list of dates is
Can.
CAN 2. Senior counsel is online. Yes. CAN 2. Oh, it's in CAN 1. The list of dates? CAN 1 is the list of dates, not CAN 2.
But in CAN 2, after synopsis, my lord, there are list of dates.
Oh.
Lordship, fine, my lord, it's written in by hand.
I don't know how we work from this. Pathetic condition. Huh? It is there in CAN 2, but he's saying CAN 1. You won't find it in CAN 1. Please find it in CAN 2. Give it.
But in CAN 2, after synopsis, Lordship, find my lord, the list of dates. There is no separate list of dates.
Not in the opposition, your lordship, in the application.
CAN 2, yes, it is there. So it is, this is the list of dates. Building plan was approved. 16/8.
Apply.
For approval, it was applied to e-district court on 16/8/2021.
Applied, yes. In this case, there is no find. What is the structure that has been erected?
Only, my lord, the pillars. Pillars up to roof level. Lordship, find it from
Page number 17, if you lordship enter to page number 17. As per report, the foundation thin beam and column up to ground floor roof.
Page 17.
Page 17.
remarks.
Remarks follow.
As per site inspection report, construction has been commenced before getting its approval from this end.
Follow up to ground floor roof level.
Has been constructed so far. So in this case, there is no scrutiny of everything, and it is not similarly situated as the earlier writ petition that it is in accordance with all the other requirements. There, you had verified the plan, you had verified the documents, all that you had done. Here, it has not been. Where do we get this?
Well, page 16, my lord, page 16.
Yes, as per building rule and as per submitted plans. No violation or deviation found beyond the submitted. And the order is same or there is a different order? No, the honorable single judge's order. Same, opposite order.
Same.
Already the 3rd of October 2024 in page 28, Your Lordship.
No, the order is separate. It's not a composite order.
Order is separate, but date is same. Same goes on.
So here the direction is in which paragraph? There it was paragraph 36 to 39. Regarding 1811, where is the finding of the honorable single judge?
For 7 and 8. It has been submitted the aforesaid Obijit Motak and petitioner both lie on the same footing and similar relief may be granted to the petitioner. Only exception is that the retention fee was accepted by the corporation from Obijit Motak, whereas in case of the petition, the same has been refused. Paragraph number 9, instant petition starts adjourned in 11th November. The corporation is restrained from taking any steps or further steps in terms of the improved communication dated 26 October 2024.
But my lord, on perusal of page 16, my lord, I find that initially it was accepted. If your lordship kindly consider page 16.
Not required. The issue is still pending before the honorable single judge. We
Yes,
don't
my lord,
know
yes.
what
Yes,
finding will be recorded. We don't.
I'm just
These issues are open to you.
Yes, my lord. The only one thing just I point out, but
The
here, my lord,
admitted position is twofold. One is structure has been erected without prior sanction. That is an admitted position. The second is there is no deviation or violation of any. These are the two admitted positions. Everything else is open for the honorable single judge to decide. So we'll dispose of in the same terms. So in both the cases, we'll give you liberty to mention before the honorable single judge because that date has now lapsed. The date which was fixed has lapsed. We don't want to fix a date. You mention before the honorable single judge and you can get it listed. That liberty will give you, this will be disposed of in the same terms.
Grateful, my lord.
After court, right? At 3:30, that order will completed. The second case order can be corrected at time.
Item number 5. Six.
My lord, I'm led by Mr. Saptamshu Basu. My lord, due to some difficulty, he is not available right now. My lord, kindly keeps the matter on Thursday, my lord.
Well, then let it go to next.
There's something urgent.
No, my lord.
There, but I've been instructed to
Already. As
for Thursday, my lord.
as paid by learned counsel for the, it's a appeal
Appeal, my lord.
for the appellate.
Item number 7. Number 7. Item number 8. For the respondent. Item 8.
My lord, in this case, we had referred to your lordships for judgment passed in.
Nobody is here. Let's see. Not today. Tomorrow.
My lord, in that case, tomorrow, my lord, I may not be able to appear due to the elections. Mr. Sinha, you will.
Maybe both will not appear. Let it be tomorrow. All the matters which nobody is there already, you have given a resolution.
And today is also 3:30. $55 na কত? আগের টা শুনলাম।
It is 59. যে অর্ডার আমরা রেফার করেছিলাম তো 59 ম্যাচ। ফাইল তো কাজ নেই, ওটা অন্য এটা অন্য ম্যাটার, ওটা ফাইল আসবে না।
ফাইল আসবে না, খালি ফাইলে অর্ডারটা
59 তো ফাইল আসবে না। ফাইল চালু আছে তো। দেখো
Item number 9. Item number 10. 10.
Learned counsel is unable to appear due to medical issue. I don't award the matter, I'm just instructed.
After nearly 1 year.
You wanted to stay out of them forever. You ask your instructor come tomorrow, not today. When you are done, it's just for class. Item number 11.
Your Lordship, behalf of the wife, actually it's a divorce petition filed by the husband. It's a divorce petition filed by husband. We are behalf of wife. Actually, what happened, Your Lordship, there was a direction last order, Your Lordship's order, it's to file fresh affidavit of service. We have sent the service, but right now I don't have any instruction after that what happened. Right now I don't have, we have sent it, but we have no instruction right now. I have no instruction. Yes, my lord, yeah.
Yes, make anything better. What do you want to do? You want to
That I have to take instruction.
Whether you want to.
Your Lordship, kindly fix it tomorrow then.
Yes, something concrete. You must make as well as prayer for it.
Wait.
I think that would.
Item 12.
In this matter, Your Lordship, learned senior counsel has left the town. Actually, she left for Calcutta. Personal difficulties.
I think the former political status about the service. Why is here something required for it? The time for checking service.
Actually, your Lordship, I had instruction. I just now, 2 hours ago, I had instruction that she will conduct this matter virtually tomorrow.
Lordship, we are for the appellant, my lord. My lord, this present status scenario that is prevailing, my lord, there is no petition for final degree has been preferred before the trial court. So, my lord, I may be permitted to not press for the time being, not press the stay application, and Lordship will be kind enough to direct for preparation of paper book. After calling for the trial court record, so the appeal can be expeditiously heard. Obviously, my lord, I will pray for a leave in future if I'm threatened. But as of now, my lord, may kindly direct for preparation of paper book. Yes, ma'am. Everything has been done. Service, my lord, regarding the stay application, my lord, we could not effect service on only one of the respondents.
Yeah.
No, I am not pressing, my lord. So I am praying that a paper book will be prepared and LCR will be called.
All right, as trade next.
Obliged, my lord.
But.
Fifteen.